It's 5 o'clock. Your lawyer is not in funds from the bank yet. Your closing is scheduled for today. You've got an hour in essence to close an escrow. And at this point, really, you have no basis for an understanding that you will be able to close today. Now, as it turns out, you're technically in breach of contract. If you're not able to close pursuant to the agreement of purchase and sale, you will be in breach. Now, ordinarily, the sellers have the option of walking away and mitigating the loss by relisting the property and telling you goodbye, Charlie. Now, normally what will happen is that the buyer's lawyers and seller's lawyers will be able to come to terms on what we call an extension agreement. As a part of the extension agreement, oftentimes they'll ask for a subsequent deposit to be applied against the purchase price, which is a norm, it's a standard, but sometimes they'll be very harsh about it and say that if you fail to close, basically the original deposit held typically with a listing brokerage will be forfeited immediately, along with the new deposit. In addition to these things, there's also what we call calculated per diem. So for example, your mortgage may be calculated at $22 a day, and for the next 5 days as a part of the extension agreement, you agree to pay those per diems to the seller. In addition to that, you're probably going to be paying the seller's lawyers legal fees, typically between $100 and $500, depending on the actual work that's done. And some law firms just charge whatever they want to charge, but you have to, in essence, agree to those things. What we're seeing more and more is that the seller's lawyers or attorneys are asking for damages and almost as a form of compensation. So we had a situation where the seller's attorney basically wanted $10,000 as a result of the breach, and there was no basis for it. As a purchaser, you should appreciate, and your lawyer should explain this to you, that you will typically be obligated to pay damages. Now, damages don't come out of thin air. They're not conjured. They have to be based on something. There has to be something that they're anchored on and have some basis for the same. So when a lawyer says that you need to pay $10,000 because you're in breach of contract and there's no basis for it, you technically should consult your lawyer and see what your rights are, because you may not be obligated to pay those damages. Now, what we've seen in these sorts of situations, especially when we're acting on the buyer, is that we have to agree to the majority of the terms, and we will accept the legal fees and the per diems and other things. But when it comes to the unsubstantiated damage or damage or compensation that they're looking for, we'll basically say that we don't agree to those things, but we're closing anyways under duress, and that after the actual transaction closes, we will be seeking legal remedies to have those damages or compensations reversed. As a client, after you speak with your lawyer, you should appreciate that damages have to be substantiated. Again, to reiterate, they can't be just conjured out of thin air. And if there's no basis for those damages and you close, be sure that you close under duress, and so that way, after the closing, you may be able to go to small claims court and have those damages reversed. I hope this video helps. If you need any support, you can always call us at the law office, and we'll be happy to assist you. Thank you. Bye for now.